Perfect, thank you.
Yes. I'm going to call this special meeting of the State Ethics Commission to order. We've got an agenda today that's in 3 parts. Have all the commissioners had an opportunity to review the agenda?
Yes.
Yes, sir.
All right, are there any changes to the agenda as presented by virtue of the commission or the commission staff? All right. I'm going to make a motion to adopt the agenda as proposed. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right. We're going to go ahead and move then to item number 2 on the agenda. I'm going to call case number 25-0060-C in the matter in the matter of Georgia Republican Assembly, Inc. and Georgia Republican Assembly, PAC, LLC. Will council go ahead and identify themselves and the parties that they're going to be representing? Which number are you? 12?
See it?
Hi, Elizabeth Young from the Attorney General's Office for the Commission.
Thank you, Rick.
Ms. Bernard?
Catherine Bernard here for Georgia Republican Assembly, Inc.
Do we have anyone present today for Georgia Republican Assembly, PAC, LLC? All right. Ms. Young, tell us just procedurally first why we're here today.
Sure. We are here today on a request from our office to review an initial decision of the Administrative Law Judge from Office of State Administrative Hearings in the case of State Ethics Commission versus Georgia Republican Assembly, Inc., and which I will call GRA, Inc., and Georgia Republican Assembly, PAC, LLC, which I will refer to as GRA, PAC, or together I'll just refer them to them jointly as respondents.
All right, before we actually get into any merits today, and Ms. Bernard, I'm going to ask you some of these questions as well, but we're going to go through this procedurally to be sure that we're doing this correctly. So my understanding is that if the commission takes no action on an initial decision of an administrative law judge, that decision stands as made. Do both sides agree?
Correct. If the commission does nothing, the decision becomes final by operation of law within 30 days.
Ms. Bernard, do you agree?
Yes, we do.
All right. The authority that the commission has with respect to an initial decision of an administrative law judge is a majority vote to vacate that decision and to set the case for a final hearing before the commission. Do you agree, Ms. Young?
I believe that to be correct. I do think, there's a bit of a conflicting analysis between what the statutory APA language says and what this commission's rules say. It basically is the same effect, but the APA language speaks of reverse or modified, and does not provide for vacating. Essentially, it's kind of a distinction without a difference, though the commission has the ability to either accept the decision, reverse it, or modify it.
All right, we'll use the terminology then as reverse. Ms. Bernard, do you agree with that part of the procedure?
I agree that that is the procedure, although, of course, we think Judge Capraro's order tracks the statutory language pretty well, and so if there are any concerns with this order, we do think it would be appropriate to take it up with the legislature regarding their statutory interpretation rather than keeping it within this agency question.
I am
So we agree
nowhere.
that that is the procedure.
I am nowhere into the merits of any matter at this point. I'm only talking about the procedure. I want to make sure that the commission staff, and your client all have an agreement with regard to the procedure. So with regard to the procedure, that it'll be a majority vote, one way or the other, whether to reverse the decision of the administrative law judge. If there's no motion made with regard to reversing that decision, then the decision will stand as made by the ALJ. Again, procedurally, Ms. Young, is that correct?
That's correct.
All right. Ma'am, is that correct for you procedurally, Ms. Bernard?
Yes, y'all do have the ability to do that under your statute, but I think as Ms. Young pointed out, should this continue, should the commission decide to do anything with regard to Judge Capraro's decision, then we are going to be in a position of having to look at those disparities between the Administrative Practice Act and the State Ethics Commission enabling legislation. But yes, overall, that is what y'all do have the ability to do today.
The commission staff, as I understand it, Ms. Young, you guys have filed a motion for commission review of an initial decision of the administrative law judge, which in this case was ALJ Dominic Capraro. I would interpret this as a motion for the commission to address this case for purposes of determining whether the commission will take action to determine whether to vacate or, as you put it, reverse the initial decision of ALJ Capraro. Do you agree with that?
Yes.
Ms. Bernard, do you agree with that?
Yes.
All right. If that motion is granted, the commission will proceed to hear argument on the question of whether ALJ Capraro's initial decision should be vacated or reversed, in which case this matter would then be put down for a final hearing before the commission. Ms. Young, do you agree with that process?
With a caveat, in order to be fully compliant with OCGA 501341, it does not, 501341 does not seem to contemplate a second hearing outside of the 30-day period. The commission can do that, which would be consistent with its rules and also be consistent with 501341, but it would, if the commission does not reach a merits conclusion today, our recommendation would be that the commission enter an express order continuing the proceedings for an additional 30 days, which is permitted by 501341 and 501317, just so that there is no question that anything has become final by operation of law in that intervening period.
So, did I understand you say for procedurally that the commission could determine the merits of this case without an APA hearing, or did I misunderstand what you said?
I believe you misunderstood it just a little bit.
Could you restate it for me?
We've already had an APA hearing, so we're past the point of an APA hearing and we're reviewing the results of the APA hearing. But under 501341, the commission has to do two things within 30 days. It has to either make a decision on the merits or it has to issue a continuance order that would give the commission an additional 30 days. The commission could deliberate on all of this today and reach a merits conclusion, but does not have to do so. I'm simply bringing this up to recommend that if the commission wants to table the matter for further consideration of further proceedings after today, that to avoid a technical argument that something has become final by operation of law, it would want to enter an extension order that's consistent with 501341.
That's only going to be the case if the commission just takes any action today with respect
Correct.
to the ALJ's decision.
Correct.
All right.
I'm just trying to make sure the commission understands that if it wants to take further action after today, that extension order would be a requirement.
Okay. Ms. Bernard?
Yes, we agree with Ms. Young as to the timing of your requirements under the statute.
All right. Now, there's a motion pending then from commission staff, the way that I understand it, to review ALJ Capraro's initial decision. This is only a motion to move forward with reviewing the ALJ's initial decision, not a motion on the merits of that initial decision. We may get to that depending on what the commission does with respect to this first motion. Ms. Bernard, is there any objection to the commission staff's motion for the commission to review today Judge Capraro's order?
No, I think that you are entitled to review the order under the stat.
All right. So I'm going to call the question with respect to the pending motion as I understand it. All in favor of granting the commission staff's motion for commission review of the initial decision of the administrative law judge, say aye. Aye. Any opposed? I don't hear any. Therefore, that motion is going to be granted. Based on the fact that we've granted that motion, we're now going to proceed on the merits of whether the commission should take any further action in this case with respect to the ALJ's decision. Are there any questions for me by commission staff before we proceed in that, any questions in that regard from any of the commissioners before we proceed in that nature?
I have.
Commissioner Wise?
What is the difference between vacate and reverse?
They're functionally the same thing. I just think that the commission would probably want to use language that's consistent with statute.
And therefore, I'm going to use the terminology reverse rather than vacate, because again, I think it's essentially the same thing. Are there any other questions for me or for Ms. Young or for Ms. Bernard with respect to where we are procedurally?
And I understand that you said that the commission staff had a motion, but by Robert's Rules of Order, do we not have to do the motion in a second, or can the staff actually make a motion?
I've got a written motion from the commission staff for us to be here to review the ALJ's decision. Given the fact that the staff has proposed that motion, I've addressed the motion, and so now I think we are here for the purposes of substantively reviewing the ALJ's decision. Thank you. Any other questions from commissioners to me with regard to procedure or for Ms. Young or Ms. Bernard in that regard? All right, hearing none. I'm going to let you proceed here in a second, Ms. Young, but again, I've got some preliminary questions that I would like to ask you with regard to substantive review of the ALJ's order or decision. So, all right, I'm going to refer to these two entities today, and I'm not trying to make anyone else necessarily refer to them this way, but I'm going to call them GRA PAC and GRA Inc. So you have an understanding of the two entities that I'm going to be referring to, okay?
Okay.
All right. So as I understand it, GRA PAC was registered as a PAC, is that right?
Correct.
All right. Are there any allegations in this case against GRA PAC in its capacity as a PAC?
No, to these, if I understand your question correctly, the allegations against GRA PAC were that it should have registered and reported as an independent committee. I believe that it did register and report as a PAC, and I don't believe there's an issue with regard to those particular obligations.
Again, that was my understanding. I just want to make sure that I'm eliminating, issues that aren't before us.
Correct.
All right. So there are no allegations against GRA PAC with respect to their operations as a PAC.
Correct.
All right. Which, sorry, I'll get it figured out.
And Ms. Young, as the GRA PAC, did they make contributions to candidates in their capacity as a PAC?
Yes, they did make, they made proportionally more contributions as independent expenditures, but they did, I believe the amount was $80,000 and change in direct contributions to candidates or their campaigns.
So as a PAC, since they contributed over $25,000 directly to candidates, monetarily, they would show up on their disclosure reports as, however, that roughly $80,000. They would then be required to register as a PAC under the Campaign Finance Act and then report, I think the filing schedule is in line with candidates as well. Is that correct?
Correct.
Okay, so they operated as a PAC as we traditionally see PACs in this state then?
At least in part, yes.
Yes, okay.
Now, as I understand it, GRA Inc. was not registered, period. Is that right?
Correct.
All right. Are there any allegations in this case against GRA Inc. in a capacity as a PAC?
No.
Okay. Was GRA Inc., from your perspective, at any point in time acting as a PAC?
One could argue that that is the case. That was not a violation that was referred to us by the commission, so we did not explore that. I think an argument could have been made potentially, but That's not an argument that was before the ALJ, or we would contend is before the commission today.
And again, my purpose in sort of going through these initial questions is to make sure I'm eliminating, issues that are not before us. And so regardless of whether anyone thinks they were operating in that capacity or could have been operating in that capacity, that question is not before us today.
That's correct.
All right. All right, I'm going to go through a little bit more, and then I promise I'm going to let you, give us your presentation. But I want to make sure that I have the allegations correct that are before us
Sure.
today. All right. So the allegations against GRA PAC were that it also acted as an independent committee, but it didn't register under 21.534, right?
Correct.
All right. It violated 21.534. Again, this is alleged. They violated 21.534 F1AC 15 times by failing to file independent committee disclosure reports.
Correct.
All right. And then the third allegation, as I understand it, is that it violated 21.534 F2B 34 times by failing to report and itemize certain expenditures.
Correct.
All right. Now, is there any dispute from your perspective that GRA PAC did not file 15 independent committee disclosure reports?
None.
Okay. Ms. Bernard, is there any dispute on your side that GRA PAC did not file 15 independent committee disclosure reports?
So I do not represent GRA PAC. That's part of the issue here, is that they are two entirely separate entities. So that is my understanding of the facts that have come out during this entire process, but I do not represent GRA PAC.
I'm well aware that you don't represent the PAC. I'm just asking if there is any dispute on the part of GRA Inc. that GRA PAC did not file 15 committee disclosure reports.
The issue, of course, is that they filed all of their disclosure reports as a PAC, and they did not also file them as an independent committee. So my understanding is factually there is no dispute that all of their disclosure reports of the GRA PAC were filed as a PAC, and that there were not additional ones filed as an independent committee, yes.
All right. Again, the only question was whether they didn't file the 15 independent committee disclosure reports. The way the evidence has come out, you don't dispute that, do you?
No, they filed all of their disclosure reports as a PAC, yes.
All right. Ms. Young, is there any dispute that GRA PAC did not report and itemize the certain expenditures 34 times?
No.
All right. Ms. Bernard, do you dispute that?
I'm honestly not in a position to be disputing allegations that are specifically against the PAC and speaking on their behalf. We brought up this concern at the Office of State Administrative Hearings, that since the people legally responsible for the PAC or their counsel have not participated in any of this process, that there is kind of a risk that because GRA Inc. is the one that shows up, that we are then held responsible for everything. So I don't feel comfortable being in a position to comment on the evidence specifically against the PAC beyond what is contained in Judge Capraro's order and previously provided testimony.
As you're here before us today, do you have any evidence that they did report those certain expenditures 34 times?
No, I think it's very clear. They reported as a PAC.
Okay.
And the position again that Judge Capraro validated in his decision is that that's what the statute requires. And so my understanding is that the position of the Ethics Commission has been that it should also be reported as both a PAC as an independent committee. But since of course we've all seen the coverage on this issue, there is a lot of attention trying to be paid, and they didn't report in this way. And so I do think, from my perception of the evidence from the other party in the case, it does look like they did report everything, all of their expenditures, just as a PAC, not also as an independent committee.
Okay. Ms. Young, is there any dispute that the only issue then is whether GRA PAC had to register as an independent committee under 21.534, which would have triggered the requirements to file those disclosure reports and to itemize those expenditures?
Yes, with a caveat, if the commission were to disagree with Judge Capraro's decision, I think the commission would then have to decide whether or not penalties were appropriate and what the mechanism would be for imposing those. But yes, in terms of the merits and in terms of liability, that is the issue before the commission.
It all comes down to that one point. This was the reason I was trying to go through all of this. When it comes to the PAC, the only question is gonna be whether they were also an independent committee that then should have filed those independent committee disclosure reports and to itemize those 34 expenditures.
That's correct.
All right, so that's the only question when it comes to the PAC.
Except for the subsequent question of what to do about it if the commission finds yes.
Okay, all right. With respect to the work that you've done with commission staff, did GRA PAC ever file an answer
No,
to the commission complaints?
no,
Okay. Is there any dispute that GRA PAC waived the preliminary hearing and actually stipulated to reasonable grounds that it violated the act?
no, that's correct.
Can you repeat the last thing you just said?
Is there any dispute that GRA PAC waived a preliminary hearing and stipulated to reasonable grounds that it violated the act? And that's what happened.
That's exactly what happened.
And that was the same day that we had the preliminary hearing with regard to GRA Inc.
That's correct.
Is there any dispute that no one showed up on GRA PAC's behalf at the OSA hearing and that no post-hearing brief was submitted on its behalf?
No,
From the perspective of commission staff, does all of that constitute any type of admission by GRA PAC such that it did also act as an independent committee and as one, take upon itself the requirement to file those disclosure reports and report and itemize those expenditures?
I think that's entirely correct.
Does that mean that the ALJ then at least got it all wrong when it comes to GRA PAC?
I think that's a entirely correct interpretation of the situation.
I guess my next question then is if that admission applies with respect to GRA PAC, why wouldn't GRA Inc. be bound by GRA PAC's admissions?
That would probably be a question for GRA Inc.'s attorneys to address more fully. We would, because the OSA rules on default we do not have a default rule the way some agencies do, so it's a little unclear how an ALJ is to handle it when an entity goes into default. We did not argue at the hearing that GRA PAC's default was somehow binding on GRA Inc. and would prohibit them from raising their own offenses.
Wasn't a lot of the evidence that was proposed at the administrative hearing, wasn't it based on the fact that GRA Inc. was actually the alter ego of GRA PAC?
Yeah, sort of. We did raise that they were an alter ego. We actually kind of led with a simpler argument because the definition of independent committee refers not just to single entities but groups or or combinations of individuals. So we felt that under the statute, when you have two organizations operating together, they are both liable for those obligations under the statute without ever having to reach questions such as piercing of corporate veils and alter egos, which is a more complex analysis. We did think that the facts were there to support that, and we did make that argument in the alternative, but our leading argument was that the statutory language covers groups and that these two organizations operated together as a group.
All right. Any other questions for Ms. Young before she starts? Go ahead.
Okay. Well, we've covered the background and the why we're here today, so I'll kind of skip straight to the merits. As y'all are aware, the administrative law judge, after a full hearing, with a full record of evidence as to these violations, looked at the statutory language of 21.5.3, subparagraph 15 of independent committees, and focused on the phrase "other than a political action committee" that is encompassed within that statute, and interpreted that to mean that if an entity calls itself a PAC and registers itself as a PAC and makes purportedly, the DLJ doesn't even address this, would be required to make at least one PAC donation, that any amount of activity that fits the definition of an independent committee would not allow the commission to regulate that entity. The problem with that is that this type of an interpretation of the statute basically creates an open season for dark money in the state of Georgia, which is why we thought that the commission should review this and consider whether or not this definition should stand. Under Judge Capraro's reasoning, which by the way is inconsistent with prior holdings of the Office of State Administrative Hearings, I did want to call to the commission's attention that we had a case called In Re School Reform, in which case number was 2016-0046, in which we had a very similar situation, and Judge Fry, a different administrative law judge, reached the exact opposite conclusion and found that it is not what an entity decides to call itself that is determinative, that you look to the actions, the nature of the expenditures, and you make the appropriate determination. He actually even looked specifically at the language that Judge Capraro looked at, the other than a political action committee, and found that that was the legislature's way of distinguishing between, to try to make it clear that just because you have engaged in some activity doesn't always make you an independent committee. That was the legislature's way of saying you've got to look at the nature of the expenditures to decide what a committee is. The problem with Judge Capraro's decision, as we see it, is that it allows the filer to determine what laws do and do not apply to them. If this decision stands, then, committees can simply decide which entity they would rather be, file as that committee. If they really want to cover their bases, make a direct donation to a candidate, and then it is open season on unreported independent committee expenditures. Since 2015, the commission has said we're not going to allow that to happen, and has advised filers that if you are going to do both types of activities, you need to register and report as both. The reason that this is important is because when somebody files and makes disclosures as an independent committee, the disclosures require them to identify which candidates they are supporting or opposing. That is not true when you register as a PAC, and that's why the fact that DRA PAC did file disclosures isn't enough here. Because they had over $220,000 worth of independent expenditures that nobody in the public in the state of Georgia can look at and determine which candidates were benefiting or being adversely affected by those expenditures. The purpose of the Campaign Finance Act at its core is to require that kind of disclosure so that the public does know, when moneyed interests are supporting a candidate, where that support is coming from, or when moneyed interests are opposing a candidate. Had they filed the independent expenditure disclosures, people would be able to look and see, they were supporting candidate A or candidate B. In this case, there was no indication. The commission had to use its powers of subpoenas and other investigatory tools at its disclosures, at its disposal to try to recreate and reconstruct where this money had gone and which entities which candidates were being supported by these expenditures. But even today, if a person wants to know, where this $220,000 worth of expenditure had gone and which candidates benefited from that, they have no way of looking at the commission's records to try to figure that out. And that's exactly why the legislature passed the independent committee rules and regulations, was to try to require this disclosure. As you know, the legislature's been very clear, it does not want dark money in the state of Georgia, and it's exactly what will happen if Judge Capraro's decision is not reviewed by the commission. When courts look at how to interpret a statute, one of the cardinal rules of statutory construction is that a court should not adopt an interpretation that would lead to absurd results. That's exactly what is happening here.
I think that Commissioner
Yeah.
Cusack's got a question.
Ms. Young, and I'm going on your argument right now, and I wanna pause and talk about what independent committees are required to disclose, and then contrast that with what PACs are required to disclose. So if, the way I read this, if this decision were to stand, independent committees have, one, they have to disclose who they are advocating for or against on a disclosure report.
Correct.
And then on the PAC side, that's not the case. Those disclosures aren't going to have, this was in favor of X candidate or against X candidate. All of a sudden, that statutory requirement has now gone away.
Correct.
And then the second part is, any independent committee or any independent expenditure that goes out to the general public, say it's a mailer, say it's a commercial, anything like that, has to disclose the entity, the independent expenditure group that is backing this communication. So when we talk about there's no dark money, it's that these actual communications have who is financing them. Because the public needs to know these things, and they can go and do their research and make a determination as to why this group may be backing them, or what ties this group may have. All of a sudden, if you take this decision and let it stand, that requirement is now gone away with the PAC disclosure. So what this decision has basically done is invalidated a lot of the public notifications, that the public protections that are in the act, that the act seems to do to shine money on who is funding what. Those protections are done away with.
Correct. I mean, that's exactly what happened here. If you look at the disclosures that were filed, you will see, for example, and this is not an exact number, it's just kind of more of a hypothetical, but you'd see something like, $20,000 to this print shop. That doesn't tell the public anything other than the print shop made some money, but it doesn't tell the public what it needs to know, which is, well, we were paying to print flyers for candidate X. And that is what is supposed to happen under the independent committee statute and regulations.
But I'm gonna go ahead and anticipate, and especially based on what she's said today, Ms. Bernard's argument. It's gonna be, this is gonna all come down to a, statutory construction with regard to the definition of an independent committee. I mean, I know that she's gonna argue that, and I think that there is some merit in that. It's defined as any committee, club, association, partnership, corporation, labor union, or other group of persons. But then it includes this phrase, other than a campaign committee, political party, or political action committee, which receives donations. I mean, doesn't the definition of independent committee exclude political action committees such that, it's either one or the other?
Well, there's two problems with that theory. First of all, who's deciding that GRA PAC is a political action committee at all? And I think that's the number one problem with Judge Capraro's decision is Judge Capraro let GRA PAC make that decision. The law makes that decision, not the regulated entity. If we let regulated entities decide which type of entity they're gonna be, again, open season on dark money, because they'll just decide to be PACs. When you look at the conduct of this organization, how does one determine which one they are? Well, you had a vastly larger amount of expenditures were independent expenditures rather than a PAC. So if you're correct and you have to pick one or the other, I think at minimum Judge Capraro erred by just going along with the assumption that the one you pick is PAC. Beyond that, when you look at statutory construction, when we look at this other than a political action committee, you do have to think about what was the legislature trying to achieve with that. I think that what is fair to take into account is that, you have had political action committees that have operated exclusively as political action committees. And I think the legislature wanted to make it clear that if that's what you're doing, these rules don't apply to you. It's not entirely clear whether the legislature contemplated these kinds of hybrid organizations or not. That's why when this came up before the commission in 2015, it had to think about what to do and issue its advisory opinion. Now, if the commission wants to revisit that opinion, what the commission did in 2015 was say, we're not going to require you to be two separate entities. We're not going to require you to form two corporations and have two separate sets of bank accounts, but you are going to have to register as both. If the commission wants to revisit that guidance, it could do that. That is one way that the commission could choose to handle this, is to say, okay, you know what, we're not going to allow hybrid entities anymore. You could say, from now on, if you are a covered entity, you better only act as one kind of entity or another kind of entity. If you want to do both things, you're going to have to set up two separate organizations and two separate sets of bank accounts. That is something that's within the commission's purview to consider. I would defer to the commission and staff in terms of whether that's a good idea or a bad idea from a practical standpoint.
What I'll say with regard to that, at least that advisory opinion that you referred to in 2015, I don't think that any of the five of us were on the commission at that point, but Commissioner Thompson's got a question for you.
So, I'm a simple person, but I can read the law, and it's very clear that it's not defined what letters you put behind whatever organization you have, but the law is your actions determine what you are, okay? So if you make independent expenditures, I don't care if you're a candidate committee, I don't care if you're a PAC, this is, to your point, and I believe you used this word, absurd ruling. I started at the Ethics Commission in 2004. It has been a long-standing historical precedent that what you do determines what kind of committee you are, not what you call yourself.
That's correct, and I think that's consistent with statutory definitions too, because what's fundamental in both the definitions of PAC and the definitions of independent expenditures is it follows the money, basically.
May I ask a question?
Commissioner
I just
Day.
want to, this almost goes back to, not to procedure, but sort of foundational. I want to be sure I understand if a campaign committee or a candidate does not have to disclose, is the reason the disclosure is not necessary because it's like transparently obvious who they're supporting, who it is supporting?
Well, so with a PAC, everybody knows who's being supported.
That's my question.
And it's reflected both in the PAC's disclosures, but you also would see that as a donation on the candidate's disclosures as well. So it's really pretty clear and easy to see, when a PAC is supporting a candidate.
So the need for transparency is already satisfied.
Correct.
With respect to a PAC. So then, as I'm understanding it, the purpose of the requirement that independent committees disclose is to address groups that might funnel money to a campaign, but without acknowledging that it does, so that the reason that they're not addressed is because it wouldn't be the reason for the distinction is it's not necessary for a PAC to disclose because it already is disclosed.
Correct. And with an independent expenditure, the candidate may not even be aware that this is going on.
Right.
So the only entity that can really make the appropriate disclosure is this independent committee. You've seen cases, I'm sure, where a politician will say, hey, that wasn't me, I had nothing to do with this, and that may very well be true. And if this entity that's doing this thing has not made that disclosure, then, you know, it can be very difficult for people to connect those dots.
Because I read that clause that the administrative law judge relied upon, other than, I did not read that to say excluding. I read it to be conveying the fact that we don't need to make these rules with respect to PAC because
Correct.
it's transparently obvious.
Correct, so, you know, if you're operating as a PAC and only as a PAC, you know, that other than a political action committee makes perfect sense, because it's saying these independent committee rules do not apply to you. The problem is, you know, when these organizations decide they wanna do both, and the commission decided back in 2015, you know, fine, we'll allow that. And in fact, I think that when you choose to engage in both and you choose not to set up separate organizations and separate bank accounts, you're kind of subjecting yourself to the jurisdiction by doing that. You know, the commission has said, fine, you know, we're not gonna make you do all the paperwork of setting up two wholly different and separate and distinct organizations, but for you to be able to do this, you have to register and report as both types of entities. You know, I think that when an organization like GRA PAC conducts itself in this way, it sort of loses the right to complain about the result. If it did not want to do that, it could have conducted itself differently. But that's the way the commission has chosen to deal with it since 2015. One option that the commission has here, if it chooses to do so, is to stop allowing it altogether and say that on a going forward basis, you are no longer permitted to engage in both types of activity.
So the legislature went as far as to identify, when they created a new law for leadership committees, and tell me if I'm wrong, that specifically excludes them from making independent expenditures. So with that said, you would think they would have done the same thing and been more deliberate if they were trying to exclude PACs from, you know, being independent committees, because they did that specifically for leadership committees. Isn't that true?
I believe you're correct about that. You're testing my recall of that particular statute, but I do believe that's correct. And, you know, I think that, you know, what we have to do is take the laws that have been written by the legislature, but keeping in mind the overall broad purposes of the statute. And that's another really important part of statutory construction. If you can look at a statute and read it more than one way, and one way is consistent with the overall purposes of the statute, and the other is entirely inconsistent with the overall purposes, then that right there answers the question of which type of interpretation you should follow.
How can you read this more than one way? I mean, the definition says, other than a campaign committee, political party, or political action committee. I mean,
Well,
that tells me that, again, you've got to be one or the other. And I want the answer not only to that, but also, if you're gonna tell me that that phrase that I just read doesn't apply here, then essentially that phrase has no meaning whatsoever. If you wanna talk about, you know, elements of statutory construction or means of statutory construction, I mean, part of it is that you don't read this in a way to make a phrase completely useless. I mean, what's the purpose of this phrase if it doesn't mean that you have to be one or the other?
So the way that we suggest that it can be interpreted is that if you have a committee that's acting entirely and exclusively as a political action committee, then that phrase applies. That the phrase other than a political action committee doesn't apply to an organization like this, that is not simply a political action committee. I think you're assuming that this definition fits entirely and exclusively the definition of political action committee, when what we really have here is something other than just a political action committee. But it is the commission's prerogative to decide how it's going to interpret this, and you know, should the commission decide to interpret it that way, that is the commission's prerogative.
Well, the only issue before us today is whether we're going to do anything to reverse or vacate the administrative law judge's decision, not the advisory opinion necessarily.
Correct, but I would caution that the commission, in thinking about what it will do here today, think about potential ramifications and ripple effects of that decision. So, I do expect that if the commission were to uphold this decision, that future regulated entities will take that as instructive. And if they were charged with if they act as a hybrid type of organization and are charged with a violation like this one, would rely on that as part of the defense. I will say that the ALJ's decision is not precedential, it's not binding from a precedential effect, but as a practical matter, it is something that the commission should expect to come up again.
Mr. Cusack first, and then
Ms. Young, I want to go to the analysis that the AL judge went into, and I want to ask if this was brought up during the hearing, but there's a provision in 2156 that talks about the precedent that's established by advisory opinions and going forward. And the commission's power is any advisory opinion or any consent order that's been entered has binding precedence on the commission. Commissioner Thompson talked about his time at the commission, where dates back to 2004, over 20 years ago, and this has been the state of operations of how independent committees and PACs have operated separately. They're under a separate reporting structure. There's different things they have to report.
he still didn't vote on that advisory opinion, though.
He did, yes, but that's been the state of play for the regulated community since that time. Was it argued or was it made clear to the ALJ that in the statute, this precedent actually matters? That this precedent is on the commission and serves as a guidepost for the regulated community? And I'm just curious if that was part of the analysis at all, because I've read the opinion, and the opinion itself seems to just hone in on one phrase that I think has a different meaning than what he was construing it to mean, but it doesn't seem to go any further than that, and there's a lot of statute, rules, and then advisory opinions that work together here, and it doesn't seem like that was analyzed properly. It doesn't seem like those were analyzed in conjunction with this.
Well, the ALJ was definitely aware of the advisory opinion, and I do not recall a discussion that was exactly like that. The decision was a bit of a surprise because this was not a heavily discussed topic at the hearing. It was discussed enough that we knew we needed to put it in our post-hearing brief, and we did address it in our post-hearing brief, but a lot of the hearing focused on other issues. So, I can't say that I expressed it as eloquently as you just did, but we did touch on it, and I do believe, I definitely know that the ALJ was aware of the decision, and I think probably is aware of the fact that people do rely on these, that there is that that rule that says that, if you do something that's consistent with the advisory opinion, we're not going to penalize you for it, even if maybe we later change our mind. That is something I would ask the commission think about as well, if it's going to entertain any kind of a change away from 2015-02, that there would need to be some kind of communication of that to the regulated entities, so that they have appropriate notice that something is going to change. Because right now, what they are told is you don't have to separate out your entities, you do not have to separate out your bank accounts. What you're supposed to do when you're doing both is file the 2 sets of reports.
Commissioner Bennett, you're second.
So I understand that the judge concluded that if you call yourself a PAC, you can't be treated as an independent committee. I get that. I don't understand what the rationale was or is for finding that GRA Inc. cannot be considered in violation. So I wonder, was there evidence presented that GRA Inc. received money and gave money?
Not directly, no. All of the, I do believe that there was a few isolated and discrete donations of money from GRA Inc. to GRA PAC, but the vast majority really was the PAC receiving and making the expenditures. There was a great deal of evidence of GRA Inc. having knowledge of and participating in decisions about which candidates were going to be supported. There's a pretty extensive record. The commission's been provided with the full set of exhibits and the probably 8 hours of hearing testimony that came in on that point. But in terms of GRA Inc.'s bank account, that was not where the donations were coming in or where the expenditures were coming out.
Commissioner Wise?
Yes, and just to understand the impact of this ruling, if it stands, that if the commission allowed this to stand, why would any entity going forward register as an independent committee in addition to a PAC when they can just report direct contributions and expenditures through the PAC and then also report unlimited spend on vendors and then hide the candidates that they're actually being supported or opposed? Well,
I would always suggest that people should follow the law and do the right thing, but as a practical matter, you raise a very, very good point, because if a committee does not like to operate under the cover of darkness, it has a very good mechanism for doing so.
Well, I guess I still think that's, it might be a key word, is that darkness then falls on the disclosures of candidates and who is opposed and supported, and that it changes everything about transparency in campaign support or opposition that this commission is all about.
I fully agree, and that's why we wanted to bring this matter to the commission's attention. Unless there are further questions, I'll just say that, in terms of deliberating and deciding on this, I kind of wanted to go over what options there are for the commission in terms of this decision. The commission could choose to let this stand either by doing nothing, by which would make it become final by operation of law, or affirmatively could affirm the decision. If the commission does not wish this decision to become a final decision by operation of law, it has several options. It can reverse or modify it as it chooses to do so, and it can do so with or without a remand to the administrative law judge for further factual findings. If the commission...
How would we modify that? I mean, it seems to me to be like a question one way or the other.
That's a good point. I want the judge, I want the commission to know all the options available to it. I, like you, would scratch my head in terms of thinking about what a modification would look like. But in terms of a reversal, the commission could choose to reverse the decision with or without the imposition of a penalty. And if it wishes to impose a penalty, it would need to make factual findings consistent with that. We have attached to our materials the proposed order that we submitted to the Office of State Administrative Hearings that contains findings of fact and conclusions of law that would support imposition of a penalty, but the commission is not required to do that. The commission could reject the decision and choose not to impose a penalty if it were to choose to do so. If the commission wishes to impose a penalty, there are two ways that the commission could do that. One would be to refer it back to the administrative law judge, let the administrative law judge review the record and make factual findings. But the commission has before it a fully developed record at this point and can make its own conclusions at this point.
Well, at the risk of being redundant,
Can you go back to the question of modifications and explain, you said we do have the authority to modify. Where is that authority provided, and elaborate on that, because I don't really get that.
That comes from the Administrative Procedure Act. that you would more typically see a modification in a case, for example, where, let's say you had taken the case to an ALJ and you found that there was liability, but the commission didn't agree that the penalty was appropriate, for example, and wanted to modify the penalty up or down. That would be the typical kind of a modification case.
Tweaking it.
Right, I think if, you know, this order contains no violation, so it seems that, you know, reversal or affirmation of that decision is really where we're looking.
Why would we consider referring this back to the ALJ when we think, or it appears to me, that there was a miss on what the legislature intended and the plain reading of the statute? It's bizarre that we would even consider.
Well, I always want to make sure that a client knows all the options that are available. Most of the time when an agency does remand back for further findings, it's in recognition of the work that is involved in making those findings.
It's just hard to want, it would be hard to give a second shot if something that was missed so badly.
And we're not advocating for that, I just wanted to be
Well,
very
you said it,
transparent with the commission that those are the options, those are the panoply of options that are available to the commission. Sometimes agencies would prefer not to have to comb through voluminous records and you know, make factual conclusions from those records, so.
You know, this is why I went through that at the beginning about procedure. It was my understanding, and someone, please correct me if I'm wrong, that if we acted today to reverse the decision of the ALJ, that we were then gonna also have to, you know, have a motion on whether to continue this matter for 30 more days, as you said, which would potentially be up to the next regular meeting of the commission, to have another hearing. Am I wrong on that?
The statute's not specific as to that kind of timing. I mean, the commission could do all of those things today, is my interpretation of the statute, or if the commission wants to take some more time to consider this, certainly can issue an order to continue the hearing and come back and visit it again.
Okay. All right. Anything else for Ms. Young at this time? All right. Ms. Bernard, you still there?
Yes, I'm here.
Okay. You want to go ahead and proceed? Well, first I'll say that I've set you up for a number of softballs, so go ahead and proceed.
Well, I should note, of course, I am a leave of absence that had been filed about 6 months ago, and so, you know, I'm coming here to, you know, make myself available. Of course, you know, this is an all-volunteer political organization that y'all have been dealing with, and so, you know, everyone you are dealing with are volunteers. You know, nobody here is receiving any money from the state of Georgia or otherwise to participate in all of these proceedings. But we do stand by Judge Capraro's order. We think that his focus on the statutory language was entirely appropriate. When we are looking at the authority that governs everybody's actions here, you know, the Georgia Constitution, and then the case law that has developed from the statutes that have been developed constitutionally. So we've got those 3 layers of authority that we're dealing with. Georgia constitutional authority regarding due process and participation, freedom of association, freedom to participate in the political process, statutes that govern law, and then of course case law under that. And so what we are here, you know, we are here before an agency, you know, the State Ethics Commission. Y'all are an executive agency, you know, chosen and put together by the executive for this purpose. And so you do not have more authority than the statutes. The statutes do govern, you know, what everybody is doing here. And so I do think that Judge Capraro interpreted the statute correctly, which was a strict construction of the statute, that when someone is seeking guidance as to how to register themselves in order to comply with the statute, they're going to read what is a political action committee, what is an independent committee, and it is very, very clear in the statute, other than a political action committee. This was a heavy focus at the hearing, it was a heavy focus in briefing, and it was a heavy focus by Judge Capraro, because I think we all agree we want to live under a rule of law, not under a rule of men or individual agency decisions that can end up colliding with each other. And so to the extent that there is any belief that the statute itself, 2153, the section that specifically excludes political action committees and independent committees from existing in the same entity, then I think going to the legislature would be the appropriate decision, particularly if this has been something that has come up for the commission since 2015. It's always a better practice to actually have the statute provide the guidance rather than providing some sort of agency level guidance about, well, the statute says this, but everybody knows you really need to do this. You know, I am a criminal defense lawyer. I practice before the courts of Georgia and frequently speak to, judges about the content of the law. And it is very important that we respect the clear language of the statute, because again, that's what the individual who is seeking to comply with Georgia law is going to go to. They're going to go to the statute. And this statute says register, you can be a political action committee, but that means you can't be an independent committee. And so I would, this is not about allowing any entity to decide what it is. In this case, it was a political action committee that was clearly identified with a particular, there was an identification with an organization and a very clearly delineated, list of candidates and people who were supported. All of the expenditures were clearly marked with where the source of the expenditure was. So, what we have here, again, I am not speaking for the GRA PAC, I'm speaking for GRA Inc., but what we have observed in all of the evidence that's out, including the evidence that was provided voluntarily as well as under subpoena, what we have is a PAC that registered as a PAC and engaged in some expenditures that could arguably be called independent committee expenditures. But as Mr. Baywall said at the hearing, this is not a dark money issue. It is obvious why this case would have attracted the attention of the commission given the actions of the Frost family outside of what was going on with the PAC or politics or anything else. It is understandable why the attention of the commission would have been attracted. But it
Ms.
is
Bernard,
very clear.
I'm trying not to cut you off, but
Certainly.
I think at this point during what you're saying is, I've got to really get you to answer the question I think that some of the commissioners have raised, and of course, a question that Ms. Young raised. I mean, when you look at this overall, isn't this really just an absurd result if we read the statute the way that you want to read it? Because it would allow a PAC to do one good thing as a PAC, but then go out and do all these things in violation of law as an independent committee. And we would have no way of controlling that activity because they simply registered and acted as a PAC only one time. I mean, couldn't you get around all of the obligations as an independent committee simply by doing one thing, and one thing even perhaps correctly as a PAC?
I mean, I think that would be very hard to stand up to, once the evidence of the expenditures was out there and once any level of scrutiny was applied to it whatsoever. So I don't think that the possibility that somebody could be abusive and seek to use the statute to conceal something, I don't think that makes an absurd result to read the statute, as it is written. I mean, Judge Capraro put it in bold in his order for a reason, other than a political action committee. This is, and again, I'm not faulting the commission for looking into this issue because obviously, everybody in the Georgia political community was caught very off guard by the news in June of 2025 regarding what was going on with the Frost family. We cooperated with the investigation. We provided y'all all the information. All of the information has been provided, and as Mr. Baywall was very clear, this is not a question of dark money or abuses of the system in any way. This is a situation where somebody reads the statute, says, we're a political action committee, so that means we file as a political action committee. So I don't think that's an absurd result, and I do think that the possibility of the kind of abuse that you describe would be an excellent reason for the legislature to tighten up this particular restriction and perhaps even designate a hybrid entity that individuals or groups that are participating in both forms of this political speech and association could then participate in. Because again, we're talking about dark money and important public policy considerations, but using the power of the Georgia government against volunteers who are speaking and associating within the political realm is a pretty dire fate as well. You know, most people can't get a volunteer lawyer to come on their leave of absence and defend against the State Ethics Commission. So, you know, we're talking about volunteers who are seeking to participate in the political environment and do so in a way that is compliant with the law. They read the law, this is what the law says. We made this argument, Judge Caparo made it the centerpiece of his decision, and so I think we really have to keep things very anchored to Georgia law and statute, because that is the controlling factor here. I did note there was some discussion in the Attorney General's portion regarding separate bank accounts. The GRA PAC had a separate bank account from the GRA Inc. The GRA Inc. was in no way engaged in any kind of, financial activity. It's a speech-based or speech and association-based organization. And so, obviously the PAC was trying to comply. They were trying to put all of their, trying to disclose all of their information. And in fact, I think it is very important to note, there's been some discussion of how independent committees can make expenditures that, the source is not noted, but the source wasn't noted on every single one of those political flyers or communications that was made. The source of the funding was noted clearly on it. So again, this is not a case where anybody was trying to conceal anything. This is not a case of dark money. This is a case of someone registering as a PAC, engaging in PAC activities, and disclosing their information as a PAC. If further guidance is needed, I think that would be great, but it should be in the context of addressing the statutory language, because otherwise we're just going to get bogged down in these endless, going back and forth with, different parts of the executive agencies. Eventually we'll get to Superior Court and have to deal with it at that stage, but it could all be fixed with a simple clarification of the statute.
Well, didn't the advisory opinion attempt to do that?
The advisory we believe that the statute is clear enough as it is to make it clear that there was no violation that has occurred. We think that's clear at this point, but, I understand independent committees and political action committees, maybe there is room for, some kind of hybrid that apparently, some other groups have been sort of unofficially participating in this requirement, even though it does seem to go contrary to the statute. I think Judge Caparo put it in bold for a reason. A political action committee under the statute can't also be an independent committee, and so it would be an absurd result to punish a political action committee engaged in valid political action committee activity for not doing what appears to violate the statute on its face.
Can I just ask one more question, just real quick? There's a question, I don't know one way or another if I actually got the answer to this from Ms. Young, but this phrase that's in the statute that says, other than a campaign committee, political party, or political action committee. If that phrase is not there for the purpose of saying you can't be a political action committee and an independent committee, can you give me any other reason for that language to be there?
Let me make sure I understand the question. So we're talking about, the definition of an independent committee.
Correct.
And so if the if that language was not in the statute about other than political action committee, would there be any other grounds for saying that you could not have both a PAC and an independent committee? Did I understand the question correctly?
No, what my question is that we've got to give some form of meaning to that phrase of the definition. The phrase being, again, other than a campaign committee, political party, or political action committee. If it's not there to say what's not included as an independent committee, what other purpose does it serve by being there?
I mean, I think the only purpose it serves is identifying other political organizations that would potentially be subject to the Ethics Commission's jurisdiction. So I mean, I think they're just outlining, it's very confusing, having to participate in all of this as a candidate, as I know y'all well know. It's a confusing process. It can be frightening for people, and, they're just doing their best to get guidance from the statutory language. So I think the point of that language is to specify, these are the types of organizations that we have jurisdiction over and that might be, considered a political action committee. But, if you're a political action committee, then you're not an independent committee.
Commissioner DeMint?
I keep coming back to GRA Inc., and I want to understand this. Do you dispute that GRA Inc. received donations from members or supporters and expended funds for the purpose of affecting the outcome of an election, or to advocate or attempt to defeat any particular candidate? Do you dispute that?
Yes. The GRA, I think, as Ms. Young mentioned, in, sort of an exhaustive history of this, volunteer organization that has had, several different individuals serving as treasurer. I think they did find like there was a small donation that was made from the GRA to the PAC, during, some point in, I think, like a 10 or 11 year period. But that is absolutely not the purpose of the GRA. Is a speech and association based political organization that is engaged in political speech and association, specifically not engaged in making direct expenditures to affect the outcome of an election.
Well, I mean, I hear you, but if you say it only happened one time and it really wasn't for that purpose, that's sort of the same sort of argument that you're opposing with respect to the suggestion that we look at the overall purpose of this whole framework. I mean, it either did or it didn't.
No, I mean, again, we're talking, like, I wanted to be clear, we are talking about activities that are so deeply regulated because they are they are First Amendment protected. We're talking about political speech and association, and, the prospect of being subjected to the investigation that has taken up, this last year and, obviously is continuing now, is the kind of thing that would shut most volunteer organizations down in an instant. Because it is, it's a threatening and intimidating situation of, we're gonna charge you $50,000 or $250,000 or whatever for, participating in politics. And so the fact that a volunteer group, at some point, made an imperfect, transfer of money, no, that is nothing like the requirements of a Georgia statute that is binding on all citizens of Georgia and all government officials of Georgia, and that being the standard to which everyone is held. So I don't think those are analogous at all with respect. I think, there is certainly the commission's goal of making sure that dark money does not influence elections is a very noble one. It's one I agree and share. But it's very easy for that kind of investigative and prosecutorial power, when deployed against individuals in the political world who are engaged in speech and association, it is very easy for it to become chilling in that regard. And so I think it's very important for any governmental agency, when dealing with a volunteer speech and association-based political organization, to be very clear about what possible actions would allow for any government jurisdiction over citizens talking about politics in the first place.
Do you have any notion why the statute doesn't say, and excluding a campaign committee, political party, or political action committee? Because I read that other than differently than the ALJ. I'm thinking that if the statute wanted to exclude those and say you can't be both, it would have said that. I read that to say, almost as if it's saying, but of course, other than of course, a campaign committee, political party, or PAC.
Well, and so if I can understand you correctly, for 2153, you know, that says any committee, club, association, partnership, corporation, labor union, or other group of persons other than a political action committee, that would define an independent committee as also being a political action committee? Because I do think this is the heart of the issue that, you know, Judge Caparo focused on as well.
To your point, we're not trying to limit free speech or, you know, political speech or anything like that. I mean, we're just trying to make sure it's reported. And under the statute, an independent expenditure has no contribution limit. So with that said, how can a PAC, just because they registered, whether they had to register or not, you know, is a different question, but just because they registered, that they could then make unlimited expenditures, and we're not even talking about if it's coordinated or not, because to your point, it sounds like you may be arguing that the ALJ, who completely missed this, in my opinion, is saying if you register as a PAC, then the contribution limits go out the window. Is that your position?
No, I mean, I think it's still important to evaluate factually what is going on in any particular situation, just so that you can avoid, you know, someone seeking to conceal, you know, large amounts of money in a way that is not disclosed to the public. So no, I don't think that reading the statute as it is written, defining political action committee and independent committee as separate entities, I don't think that you know, if there is no argument whatsoever that an entity is actually operating as a political action committee, which again, I think would be, you know, somewhat hard to do with, you know, these sort of very obvious and again, obvious and disclosed political contributions that were being made. I don't think that individuals who are making a good faith effort to follow the law as written and whose subsequent investigation reveals were not engaged in any concealment or use of dark money, I don't think it would be appropriate to sanction or punish them or even avoid clearing up this issue in the statute, because I think that could, you know, that would be of great benefit to a lot of people if there could be, you know, a hybrid PAC identified as, you know, if you are doing this activity, then you need to register as an independent committee.
Commissioner Cusack?
So, I just want to play this out real quick with in terms of independent expenditures. It's in the name, by their very nature, they're supposed to be independent. When you have a PAC that is making these independent, what are defined as independent expenditures, and the PAC has donated money to the candidate, you've changed the fundamental nature of what an independent expenditure is. And so you've just totally nullified the definition of independent expenditure and what an independent committee is. You're killing the independence, and that's why there's no contribution limits on, you know, what I'll call an independent expenditure committee, commonly known as a super PAC. So I think the way this decision has come down, it is an absurd result because you've nullified one section of the Campaign Finance Act and related to independent committees and independent expenditures, and there's a reason why these independent expenditures are firewalled from campaigns. We're in a weird place where just because it's always been content-based on how you register. And I'm still failing to see how in any way, shape, or form that we haven't construed, this decision doesn't construe the statute to just a ridiculous result that is gonna nullify part of the code, which there's case law on, you have to read everything independently and uphold it independently, so I'm still not convinced that, this decision doesn't do that.
Anything further, Ms. Bernard?
And
Oh, go ahead.
I guess I will say I am not too worried after this past year about the state of Georgia having insufficient power to examine possible violations of the Campaign Finance Act. And so I don't have a great concern that something is going to fly under the radar and that no one will notice it and someone will be able to sneak a bunch of dark money into Georgia elections. I do think that when we are the ones in position of power in, an executive agency or otherwise, it can be very easy to treat the statute as just sort of like another piece of the regulations, like another piece of the landscape in which we find ourselves. But I think the statute really deserves more primacy than that. And so all of these concerns about, potential abuses, all valid, legitimate concerns, and should be taken into consideration when crafting a statute that can effectively guide people's behavior in a lawful and constructive way, but also, not leave people in this terrifying position of, but the law says this. I thought I was doing everything I needed to, and in fact, even a wise and distinguished administrative law judge agrees with this interpretation of the law. So it's not just some, selfish person, trying to read the law to a helpful result to themselves. This is such like I would say, obvious reading of the statutory construction that, it was sympathetic even after a very lengthy hearing with the ALJ. So I would say, y'all have a lot of political power and pull in this room. There's a lot of legislators who would, I'm sure, be eager to hear about ways that the Campaign Finance Act could be strengthened, because that's a great political issue for them to talk about. I strengthen campaign finance laws. And so I think just the fact that we are at this stage in the discussion shows that there is enough of an issue with the way this statute is written that any attention going forward should be focused on clarifying the statute rather than seeking to punish individuals under the statute even after an investigation has found that there were no dark money or abuses involved.
Thank you, Ms. Bernard. Ms. Young, I'm going to let you finish since you were the movement that brought us here today.
Thank you. I think the commission has clearly been asking the right questions. I think Commissioner Thompson had a very interesting point that if this decision is left to stand, that one thing the commission may want to look into is whether or not there are contribution limits violations that have occurred. And there may be a different case that could be made not only as to GRA PAC and GRA Inc., but also as to the candidates that may have received donations in excess of their contribution limits. That may be more in the nature where a modification type of situation could come into play. We think, the probably more direct way to go about this is to read the statute in a way that does not lead to absurd and complicated results and that is consistent with the overall purposes, which would mean that the other than a political action committee is meant to apply to organizations that act exactly as a political action committee and not as something bigger or broader than that, which is what we have here. I'm happy to answer any other questions, but if there are none, I will just leave it at that.
Thank you, Ms. Young. Let's take about a 5 or 10 minute break. When we come back, now, it'll anyone wants to make a motion with regard to reversing the ALJ's decision. If there is no motion, then it would be my understanding that the ALJ's decision would just remain as is, and I guess the case would be concluded at that point. If there is a modification made, or whether it be a reversal or what have you, I think it would be appropriate at that point, so I'm gonna ask everyone to also be thinking about this, in the event that we get to it. In terms of how are we gonna set this up from there, if in fact that there is a reversal? Is it gonna be a motion that we're gonna make, with respect to, having 30 more days to go ahead and have a final hearing, which again, may not require at this point, from my perspective at least, factual findings or listening, or actually conducting another, evidentiary hearing, especially since we have, the tape recording of the prior hearing that took place at OSA. So it may just be an instance where we schedule this again for the regular meeting. I think that may be coming up, and at that point in time, I think it would just be, we would be on point to actually address whether there's going to be any type of fine issued or something of that nature. So again, I just want everyone to be thinking about that, because it may come up if the commission decides to take action and reverse the opinion of the administrative law judge. So we'll be in recess. We're going to call this meeting back to order. We're at the stage with regard to the case that's currently under review, where I'll open the floor for any type of motion to reverse, to vacate, or to reject the decision of the administrative law judge. I think first that Mr. Knittel wanted to speak to a matter of procedure that he felt like came up during some of that discussion. Mr. Knittel?
Thank you, Mr. Chairman. I did want to just talk to the commissioners about why both of these parties are tied together, meaning GRA PAC and GR Inc. I realize that maybe one or more of you may not have been around when that initial preliminary exam happened, but both of these are together as one group essentially. They're represented by different attorneys, of course, but as far as for our purposes here, there was a preliminary hearing held back when this case originally took place, where they were both respondents on the complaint, and this commission found as to both respondents that they had violated our act. So the Inc. is tied into the PAC by virtue of, and I'm going to use the phrase, the alternate ego. There were some other issues involved in that case as to why they were tied into it. But so, because it may not be clear why are we looking at, GRA Inc. When, they were, they're saying they didn't have anything to do with the PAC. However, there was evidence that was presented during the preliminary hearing in which the commission agreed with, or found, I should say, enough that they were in fact tied together. I hope that clarifies.
Well, again, what I think that I would have to say about that is that the reason that they're tied together today is that they were both involved in the same OSA matter, and the order that was issued by the administrative law judge applied to both of those entities. Therefore, if we're going to take any action with regard to that order, it would obviously involve both of the respondents that were in that case.
Yes, I concur with that. That's correct.
Okay. Mr. Cusack?
I'll make a motion if everyone is ready. I will make a motion to reject and vacate docket number 26-276-OS-AH-SEC-NCAN-38-Caparo, which is CAPRARO, just for the court reporter. And I would add to that motion that this rejection and vacate of this matter is based on the analysis of OCGA 215315, in that it is an incorrect application of that statute, and that the commission reject and vacate this OSA decision and then set this matter down to be heard for a final hearing at the next regularly scheduled commission meeting.
Second.
Got a motion and a second, is there any discussion? I've got a couple of things that I want to address now that the motion has been made. Again, a lot of, I think, the focus on what we've dealt with today is at least to me, is a matter of statutory construction. We're looking at the definition of what an independent committee is. And the way that I look at the statute and the definition of an independent committee is that this phrase, other than a campaign committee, political party, or political action committee, may serve no purpose other than to specify what is not included within that definition. However, what I heard here today as we were going through a discussion, and in particular, the phrase that I've been focused on, is that especially with regard to the beginning of that phrase, other than a campaign committee, political party, or political action committee, I think that Commissioner DeMint hit things right on the head when she said that, look, the phrase other than can certainly have more meaning than one. And then, because the phrase becomes ambiguous, I believe that we can exercise any number of rules of statutory construction that may exist beyond the language that's actually used by the legislature. So I just wanted to indicate that, and I think that once you employ those rules of statutory construction, one of the major rules that apply here is that you can't interpret this phrase that leads to an absurd result. And I think that completely taking out the situation where you can't operate as both entities at the same time, I think, as Commissioner Cusack also said, that you would essentially be invalidating an entire part of the Campaign Finance Act that would apply to independent committees. So again, I just wanted to speak to that point because I felt like I had been very focused on the terms of that statute as they were presented. Is there any other discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, that motion passes. The ALJ's decision is reversed/rejected. With that in mind, I now procedurally do want to, sorry. Okay, procedurally, I want to go forward then. It's my understanding that the next scheduled regular meeting is on September the 16th. In order to do this, Ms. Young, within the 30-day time limit that you discussed with regard to having a final hearing, I believe that if we move that meeting to September the 9th, that we will fall within those 30 days. Am I correct, Mr. Kendall, or Ms. Young? Someone?
That's correct. So 501341 provides that the commission can take a 30-day extension for basically specified reasons. Anything beyond that, there is a provision that would allow the commission to go an additional 30 days beyond that, but there would have to be a showing of, I think it's unusual or compelling circumstances that would have to be specified for the commission. So in other words, the commission, to go beyond that 60-day window, would have to have some sort of an unusual and compelling reason why it needs to go beyond that 60 days. If the commission can meet earlier and keep it within that 60-day window, that would probably be the best thing to do within the statute. Unless, presumably if counsel for GRA Inc. Is equally amenable to either date, they could consent to waiving those 501341 deadlines.
You were ahead of me on that. I was gonna ask Mr. Bernard, if we have a final hearing on this on September the 9th, are you available?
I believe I have trials set for that week, but, I'm not sure what is actually going to be going yet, so I may be able to be.
Okay. No, look, I completely understand. We've got a number of people on the commission that have to deal with any number of things, happening as well. I think what we're gonna do though, is go ahead and try to schedule this for September the 9th. And then if you can't be available for one reason or another, and I believe if you were to agree to this, we could, kick that even to the next meeting. Would there be any problem with that, Ms. Young, as long as, other council agreed to that extension?
No, I think that would be fine as long as there was a noted and clear waiver of the deadline in 501341.
Right, okay. Is that okay with you, Ms. Bernard, if we set it up that way?
Yes, I can certainly see about availability for the 9th and then the possibility of, going to the next meeting in
Okay, all right. So with regard to that, unless anyone have any other issues with that procedurally, I guess at this point. So first of all, because we have already set the regular meeting for September the 16th, I'm going to make a motion to modify the date for the next regular meeting from September the 16th to September the 19th. Excuse me, to September the 9th. Do I have a second?
Second.
I got a motion and a second. Is there any discussion? Mr. Cusack?
Is that meeting here or is that somewhere else?
That's a very good point. That meeting is actually in Helen. Ms. Easterwood, do you know if we're going to be able to move that meeting from the 16th to the 9th?
Yes, I confirmed that they're available for us to move it.
Okay, all right.
So it'll still be in Helen?
It will still, it'll still be in Helen.
Wonderful.
And Ms. Bernard, if necessary, you can certainly attend again. Well, Erwin, is that something we're gonna be set up virtually?
Yes.
Okay, all right. So Ms. Bernard, if it helps at all, since that meeting is gonna be in Helen, you'll be able to attend again virtually if you want to do that,
Thank you.
if that helps. Commissioner DeBent?
Sounds good?
Oh, yeah, your light was blinking, I'm
Oh,
sorry.
sorry.
That's okay,
Okay.
all right.
Your light's blinking.
Okay.
It might be expiring. Your light.
All right, so I've got a motion and a second. Any further discussion? All right, hearing none, I'm going to call the question. All in favor say aye. Aye. Any opposed? All right, so the next regular meeting is going to be September the 9th. The next motion I will make, and Ms. Young and Ms. Bernard, please tell me if I get this wrong, but I'm going to make a motion that that the final hearing in the pending matter be extended to September 9th, 2026 for the next regular meeting. Do I have a second?
Second.
You got a motion and a second. Any discussion? All right, I'll call the question. All in favor say aye. Aye. Any opposed? All right, so that motion carries as well. Is there anything further, Mr. Knittel, that needs to be done with respect to this case?
Nothing further.
Ms. Young, anything further for this case?
Nothing further.
Ms. Bernard, anything further for this case?
No, it looks like we've got,
So the
lots more
16th.
time to spend on it, it seems.
All right. All right. We'll go ahead and move then to the last item on the agenda, which is going to be adjournment. I make a motion that we will adjourn this meeting. Got a second? I got a motion and a second. Any discussion? Hearing none, all in favor say aye.